All right, let's get right into it. We're going to break down Chapter 1 of India's brand new Digital Personal Data Protection Act 2023. Now, this first chapter, it might seem short, but it's so important. It's basically the foundation for the entire law. It lays out the rules of the road for your personal data, and trust me, you need to understand this part to make sense of everything else.
Okay, before we jump in, just a quick heads up. This is all for educational purposes, okay? It's not professional advice. Data protection laws can get pretty complex and they change, so you should always chat with a professional advisor for your own situation. Oh, and just so you know, this is an AI-generated video.
So think about it for a second. Your personal data is all over the internet, right? Every app you use, every site you visit, you're leaving behind a digital footprint. But if you ever stop to ask, who's actually responsible for all that information? I mean, who's on the hook if something goes wrong? Well, that's the huge question this new law from India is finally here to answer. And the answer comes in the form of what you can think of as a brand new rulebook for data. Its official name is the Digital Personal Data Protection Act 2023, but you'll probably hear everyone calling it the DPDP Act for short. So on August 11th, 2023, this law became a reality, and it set up a completely new way of thinking about data protection in India. You see, it's trying to do two things at once. First, protect your right to keep your personal data safe. And second, recognize that businesses do need to use data for legitimate reasons. It's a really tricky balancing act, and this law is the attempt to get it right. Now, with any new rulebook, the first thing you've got to do is meet the key players, right? You need to know who's who. So let's break down the most important roles and ideas that make up this whole new world of data protection. Okay, first and foremost, the big one, personal data. What is it? The law says it's basically any data about a person who can be identified from that information. And you know, this is the what. It's the thing this entire law is built to protect. We're not just talking about your name and email. It's way broader than that. It's really any piece of information that can be linked back to you. And this brings us to the most important relationship in the entire act. It's a two-sided coin. On one side, you have the data principal. That's simple. It's you. It's the person the data is about. On the other side, you have the data fiduciary. Now that's the company or the app or the website that decides why and how your data is going to be used. And here's the key takeaway. This new law puts all the legal responsibility right on the shoulders of that data fiduciary. There are a couple of other important terms to note too. Processing sounds technical, but it's really just everything. Any automated thing you can do with data. Collecting it, storing it, sharing it, you name it. Then there's the data processor. The processor is the company that handles the data for the fiduciary. Think of it like this. The social media app you use, that's the data fiduciary. The cloud company they use to actually store all your photos, that's the data processor. And the Act also defines a child as anyone under 18, which becomes really important later on. All right, so we've got the who and the what down, but what about the where? As in, where do these new rules actually apply? That's what we're going to look at now, the Act's jurisdiction. Okay, so this law kicks in two main scenarios. The first one is pretty obvious. It applies to any digital personal data that's processed inside India. Makes sense. But the second one, now this is where it gets really interesting. The law also applies to companies processing data outside of India if, and this is the big if, they're offering goods or services to people in India. This is huge. It means that global companies can't just say, oh, we're not based in India. If they're serving you, they have to follow these rules. But it's not a blanket rule that covers absolutely everything. The law is smart about this, and Chapter 1 actually lays out some really important exceptions, situations where the Act doesn't apply. Let's take a look at what they are. There are two main exemptions that you really need to know about. First, the law doesn't apply to data you're using for personal or domestic stuff, like the contact list on your own phone. The government isn't worried about that. The second one, though, is a really big deal. The Act does not apply to personal data that you, the data principal, have already made public yourself. And to make sure there's absolutely no confusion here, the law itself gives a perfect example. It says if an individual, while blogging her views, has publicly made available her personal data on social media, the provisions of this Act shall not apply. So what does that mean? It means the second you decide to post something publicly, you're stepping outside the protections of this specific law for that piece of data. So, to wrap up Chapter 1, it's all about setting the stage. It tells us who the players are, what data we're talking about, and where the rules of the game apply. It is the absolute foundation. And of course, that leads to the next big question, right? With all this in place, how are companies supposed to handle your data? What are your rights? Well, that's exactly what we'll get into as we explore the rest of the Act. Thank you for watching. Please like, share, and subscribe.